Good afternoon to everybody on the East Coast. Good morning on the West Coast. I'm Shari Levitan, and I'm with Holland Knight, a partner that practices from our Boston office. The primary focus of my practice is estate and tax planning, and I prepare prenuptial and postnuptial agreements and work with matrimonial attorneys on unwinds at the time of divorce. I also advise trustees in trust administration, including during times where there are challenges for beneficiaries. I'm a member of the American College of Trust and Estates Council, and together with the American Academy of Matrimonial Lawyers, we've embarked on a series of joint educational presentations and self-education to be sure that the two disciplines of tax and estate planning and trust law and the folks who handle matrimonial matters are talking with one another about the differences of perspective during planning, administration, and later during divorce, rather than siloing our practices as being beneficial for everybody. Kim?
Thank you, Shari. My name is Kim Willoughby. I'm an attorney in the Denver, Colorado area. I am also a fellow of ACTEC, and I'm a fellow of the American Academy of Matrimonial Lawyers. And my practice also involves a lot of prenuptial agreements, but I do both sides. So we put them together and then we litigate them later. And then also I have a practice that is really focused on the place where trusts and divorce intersect. And in particular, talking about various trust interests in divorce, and also being an expert witness in that area.
Very good. So the focus for our discussion today, which will be a little bit of point counterpoint, is going to focus on third-party settled trust, not self-settled trust. And we're going to be looking at third-party created irrevocable trust, where the beneficiary of that trust is either getting married or maybe anticipating a divorce or is going through a divorce. And from the planner's perspective, we're going to be first focusing on the creator of the trust, the donor's intention, because we know that longstanding law tells the trustee and its beneficiaries of the trust that the donor's intention is paramount. And that's been reiterated in modern trust codes, the Uniform Trust Code. The donor intent with respect to the trust will govern. However, we know that donors sometimes don't think about certain things when they're creating trusts. They're thinking about tax planning, particularly this year, as exemptions are, or at least were until a couple of weeks ago, scheduled to decrease starting next year. They're not thinking always about a beneficiary's future divorce or other creditors. They're not thinking about what happens if there's a marriage that starts to get rocky, but not necessarily a divorce. And sometimes they are, and they're being guided by the estate planners who may not have a full appreciation of the kinds of things that Kim is looking for after the fact, when we now have facts that we wish we maybe didn't have. So we're going to start first with the drafting attorney's assumptions and our commonly understood thought process as we move forward. I remember being taught as a junior lawyer and all through law school and beginning to draft documents that where the trustee has discretion, that's it. It's the trustee's discretion. And the beneficiary has no checkbook to write a check from. If the trust has a spendthrift clause, the beneficiary of the trust can't anticipate distributions and assign them to an about-to-be ex-spouse. Moreover, the trust can't be rewritten. And most importantly, someone who's not a beneficiary of the trust can't, by fiat, by a judge's decree, be made a beneficiary of the trust. So a non-beneficiary spouse is not a beneficiary either directly or as a third-party beneficiary. And that's what we've told our clients for years. And when our clients come to us because their children are getting married or getting divorced, or grandma comes to us and asks the question, they often frame it, well, is the trust that I created so many years ago bulletproof? And in the old days, we might have said, well, yes. And now we want to talk through with you so that everybody has a common understanding that nothing is completely protected, but some trusts are better protected than others. And Kim's going to chat a little bit about trustee behavior along with the trust agreement itself, because there's the pristine agreement that she and I will draft. And then there's the, what is the trustee actually doing day to day in administering the trust?
But before we get there, let's talk a little bit about litigators. So I don't know about you guys, but I have noticed a very, very big difference in sort of the character of the wonderful estate planning and tax attorneys, and then litigators. And the estate planning and tax attorneys are very meticulous. They put things together. They're very exacting, and they look at they're putting things together with words and using, in particular, the tax code to make sure that there's a certain outcome. Litigators are totally different people. Litigators want to take things apart 9 times out of 10. They are doing things to get to a certain goal, and they are storytellers. And what they do is they say, I am going to tell a story with facts that I like, or facts that I can sort of smudge to work to my purposes to get to my goal. And my goal is not putting something together. My goal is taking it apart and getting to a, not a resolution, but getting to a point where one person wins and the other person loses. So for the divorce attorney, when they're dealing with a situation involving a trust and beneficial interest in trust, and we'll just here use the assumption that one of the spouses is the beneficiary of a third-party settled trust. So if I am the attorney for the outspouse, my goal is to get those trust assets or the trust income to be part of the divorce. And I'm very specific about just saying to be part of the divorce. I'm not saying I want the trust income to necessarily be income for this purpose or that purpose, or for a definition of marital property that's going to work for me. I'm just saying I want to get it in the mix. There's 2 reasons for that. So oftentimes the spouses, the beneficiary and then the non-beneficiary have had a significant financial benefit from the trust, right? So either they've used it for their cash flow purposes, or even more often, they've used it as, we don't have to save money for retirement because this is out there. We can be more spendy because this is out there. We don't have to save for the kids' college because this is out there. And the divorce comes when people have relied on that and their finances show that, but now one person isn't going to get to rely on that anymore. Then the second reason that I'm going to get this trust into the mix is because it creates leverage by being a pain point, right? So litigators are about pain points and leverage. So the other thing to understand about how divorce trials actually work is that they're about, at the end of the day, divorce or judges applying dissolution of marriage statutes have an enormous amount of discretion. And a lot of times, and in a lot of states, there are not a lot of black letter law, statutory law, and there's actually not a lot of case law. So they're just frankly winging it a lot of times, in particular in this area. And then you take the discretion and then you add it to the fact that many of the actual black letter law, the statutes say the judge has, the judge is to apply equity and be equitable and divide things equitably. That gives them basically carte blanche to do what they want to do to get to a certain outcome that is based on the story that the litigators have told. Now, compound that with the fact that judges are litigators, right? There are not judges who, by and large, who were estate planners. There are not judges, by and large, who were tax attorneys. The judges, by and large, are former prosecutors, former public defenders, civil litigators, those types of folks. So they don't understand necessarily this body of law. They don't understand it. They can be taught it, but it is not something that they can draw upon their own experience most of the time or the experience from their practices. And then finally, again, with the storytelling theme, credibility is the currency of highest value in a divorce trial. So what we do as litigators is we tell the story to say the other guy is the bad guy. So my goal as the attorney for the out spouse is to use all of those things to tell the story of the big, rich family trying to kick out the poor, innocent, got run over out spouse so that she or he doesn't have any, doesn't have the same economics as before. So where do we start to look? Well, as Shari said, the first thing we're going to do is we're going to look at trustee behavior during the time that the trust was administered. And is it consistent or is it inconsistent with the trust instrument and other trusts that the trustee is administering? So I'm going to look and I'm going to say, gee gosh, I see that the trustee, every time husband called, stroked a check. And that's what wife's story is going to be. This is a piggy bank. This is a bank account. There was never, ever, ever a time where the trustee used discretion and said no. There was never a time when the trustee looked around at other resources. There was never a time that the trustee did anything other than what the beneficiary asked for. And in fact, maybe the trustee just said, hey, go do this, go administer this yourself, call me if you really need something, but otherwise these are kind of your assets. So you deal with them and kind of tell me what you need me to do. And I will sort of backfill what your desires were, what your requests were. Then there are other times when the trust instrument will say the only beneficiary is so-and-so, or the primary beneficiary is this person. And yet trustee is paying other people as well, paying the grandchildren, paying the spouse. So I have run across times where we get to kind of attack so I'll use pierce the veil a little bit. It's not exactly, that's a corporate theory, but it kind of works here where we say, look, you've been writing checks for wife's benefit for years. And all of a sudden you stop because wife is not actually a beneficiary. So, what is that about? This is sort of demonstrating to a judge that, they're calling it this thing now that makes it not property or not an economic resource or not income to the family. And yet it's always been treated that way. So, and Shari, you might want to jump in and talk about what you see with trustees when they get caught up in this, or when they have been a little bit free and loose with what their interpretation of the trust instrument is in terms of what they can pay for, who they can pay, when they can pay, what kinds of trust assets can be used in the payments.
Absolutely. And so The trust may contain broad discretion, that the trustee may make distributions to any one or more of certain beneficiaries for any purpose that the trustees determines to be appropriate. It may conversely contain what we call a HEM standard, that the trustee shall distribute for purposes of health maintenance, education, and support for one or more beneficiaries. And that is often a tax construct that we estate planners put into the trust if we have a beneficiary who is also the trustee, to avoid estate tax inclusion for the beneficiary, or because the donor wants there to be a stricter standard, or to change the balance of power so that trustees do have a hook to come to even an independent trustee and say, I need a distribution for this. This is not fully in your discretion. You've got to take a look at this. The code section speaks to necessity, and the trust document ought to have language about whether other resources of the beneficiary with a HEM standard should be considered. What does their cash flow look like? What savings do they have? Is this necessary? And the trustee is supposed to take into account current beneficiaries and future beneficiaries, the size of the trust, the nature of the assets. This is nothing new. This is garden variety fiduciary law. But what we see sometimes is that even with a HEM standard, people look the other way. And they make distributions so that the beneficiary can in turn make gifts to charity or to other people. Or the trustee never asked the question with a HEM standard, what are your other resources? Help us out. Institutional trustees have committees and a protocol. They don't always follow their own protocols that they have. And I'm sure that one of the first questions that Kim asks if there's a trust with a certain standard or purpose is, did you administer this trust the way you do all of them? What's your policy? What did you ask for? Trustees often have beneficiaries that come to them in extremis, that, you know, they've committed to something, to pay for something, and then they realize they don't have the money, or they're accustomed to getting the payment from the trustee. The next call is to the trustee to bail them out. And it may be as simple as the out spouse's credit cards, getting them into hot water, or the out spouse needs a new car. Well, it's for the benefit of the family generally. What could be wrong? What could go wrong here? And you know that these conversations no longer take place in person at a meeting. They are texts, they are emails, they are all sorts of messaging, and attorneys take good notes usually as to the incoming request, and they should document their files. And so there's a body of backup, if you will, when these distributions are made. And the history, with the benefit of hindsight, is something that we're going to talk about here. And we're going to get into the nuances of people being a little bit more savvy than your average trustee, who think about, gee, should we make loans instead of distributions and the like? But I'd like to digress a little bit about those communications, because I've got my file full of those sorts of things when I'm serving as trustee. And what does Kim want to know in the process of things heading south?
I don't want to know anything. I want to set up a story, right? So, and I'm being a little cute with the language, but I want to set up the trustee as the bad guy, the beneficiary spouse as the one who made all of the changes. And here's how I'm going to do it. So Shari was talking about, okay, so we have the standard, and sometimes we've been a little bit loosey-goosey with the distributions and how they were made and what backup we have and what else we looked at. But the best part for the litigator is when the trustee switches it up, right? So it's been, husband makes a call, trustee strokes a check for years and years and years. Wife wants something and trustee kind of makes that happen too. But then there is the call where husband says, we're in trouble. And she is, in one of our fights, she said, I'm going after your family's trusts. And so now we're going to have to change things up. And trustee, you need to stop making distributions, because I'm hearing that she can go after the trust assets, maybe she can go after the trust income, maybe she's going to ask for support based on the trust income. So I want to just stop all of it so that I don't have that income that I need to report. I don't have that income to get into the mix. I don't have the access to the assets that make it seem like I have access to the assets. So let's change things. So that is going to be my first little toehold into creating the narrative around the big bad trustee. And of course, it's always worse when it's the brother who's the trustee or dad who's the trustee. And here's how these communications go and how I'm going to use them. So husband is beneficiary and husband calls trustee. Dad, wife and I are in trouble and I think that we're going to get divorced. And she said she's going to go after the trust. What do I do? They have a talk. As Shari was saying, they're going to be texting, they're going to be emailing. And one of the first things that the divorce attorney is going to do is send out the letter that says you will preserve all evidence, and it comes in the form of your texts and your emails, etc. So don't be going and deleting them. But trustee dad and son are going to be talking about this. And of course, it's not privileged at all. So the attorney is going to go after those communications with dad and mom or brother or sister or whoever might be in the mix, if it's a particularly close family, if there's been a divorce before and they learned bad things happen the first time, so now they're going to try to do things differently the second time. I'm going to be looking for those emails. I'm going to be deposing those people, and beneficiary son is always going to be going to dad first. Then trustee dad is going to call his estate planning attorney, and he is his personal estate planning attorney. And he's going to say, oh my God, I'm trustee and my son is getting divorced and she's horrible and evil and she's coming after the trust. And so what do I do? And then the estate planning attorney, we're helpful people. We want to fix things. We want to go, all right, here are the tools to make this better. They're going to say, well, how about we decant the trust, we move it to a South Dakota trust, we get an independent trustee in South Dakota, we're going to kick husband off as co-trustee, and we're going to stop making any distributions. Problem solved.
That's exactly the call that I get. What can we do? We know we can't cancel the trust, but what can we do to put guardrails on it?
And is that privileged? I'm going to argue that that discussion was not privileged, because that was trustee talking to trustee dad, talking to dad's attorney. So he's going in as trustee, but he's talking to an attorney who is not attorney for trustee. He's talking to his own estate planner. So my argument is this is not going to be privileged because there is no relationship, attorney-client relationship between trustee and that lawyer.
Well, but let's say that the attorney is fairly savvy and says, we need to open a separate matter here. We need to have a separate matter where we are being engaged by you in your capacity as trustee. Or I'm going to refer you to somebody outside the firm potentially who will represent you as trustee. We're aware that in some jurisdictions that if the bills are being paid from the trust, they are not privileged necessarily, that at least the beneficiaries from the trust are entitled to see the records for the bills and what was done. Not the same in all jurisdictions, but that's another potential gotcha, even if you're careful to have separate counsel. And no trustee wants to go out of pocket to pay for those legal fees.
Right. And so even if Shari can make a great argument that the discussions are privileged, the other thing that you need to know is, okay, so I don't get the document, but here's what I do get. I get a log of the things that the attorney is withholding from me on the grounds of privilege, which means if I have this enormous, so if I have a document with 500 different emails that they're saying this email between trustee dad and an attorney is privileged, if I have 50 of them right around the time of the divorce, that tells its own story. And it's awesome because a good storyteller gets a lot of mileage out of something that they don't see, but they can make some assumptions about. Well, this must be really bad in here because they don't want to tell us about it. They're not telling us about it. Look at all that communication. Here's what I think that was about. So now the communication actually might be a lot less nefarious than I'm going to make it out to be if the court can't see it. And then, you know, Shari hit on a great point. One of the things in discovery is, in divorces, it's courts of equity. And in some states, not all, but in some states, divorcing spouses owe fiduciary duties to each other. And in all states, divorcing spouses owe full and fair financial disclosures and disclosures of anything relevant to each other. If the beneficiary can get it and goes, oh, but the trustee won't give it to me, the court is going to blame it on the beneficiary every single time. So when Shari says what the beneficiary can get, you know, might be this, that, or the other thing, I'm going to make an argument that the beneficiary can get all of it. And it's just withholding, again, because they don't want the litigator to see what there is because they're big, bad, horrible people.
And when we are representing fiduciaries, we're often confounded by the fiduciary duty to other beneficiaries to not provide certain information that could damage the value of the trust, particularly if it involves a private company or something like that, where the disclosure could be very public.
Mm-hmm. That's a great point. But divorce courts will say, you know, to some extent they respect that, but they're also going to say, yeah, but those people aren't in this case, and I just need to deal with these people. Those other people can do their own. I just need to deal with the people in front of us. So then along the communication chain, so then trustee dad calls husband, and privileged or not privileged, he says, so here's what the lawyer said. Yay, waiver. Got rid of all of that privilege that maybe there was between trustee and the attorney you talked to, but he's always going to call that beneficiary husband, and he's always going to say, here's the plan, here's what we're thinking, here's what my lawyer says, and that is always going to be discoverable. So trying to and Shari, you might share some stories about how you really do it and what warnings you give to people, but how to protect those communications is really problematic. And especially because they're always when the divorce is like a year away, you know, they're not when, oh, somebody filed, so now we know it's on. It's when Christmas was crap and the beneficiary husband called dad and said, you know, I don't know where this is going, but the divorce isn't imminent even. It's just kind of out there.
Right. And those are the calls that we get because people are not sensitized and they call with a laundry list of questions about what can we do? Can we create a new trust and dump all the assets in, now called decanting? Can we swap assets? Can we put an LLC wrapper around the trust? So even if the trust is breached, the assets are all up in the LLC, and all you have is the ability to get cash flow if and when it's distributed from the LLC. Can we modify powers? As Kim spoke before, can we change the trustee and get rid of the family member who may be too close and put the lawyer in as trustee, somebody who, really has those bona fides? Can we change the trust situs to a jurisdiction that is more favorable to creditor protection, including spouses, and change the controlling law of the trust? And there are an interesting few cases smattered out there recently that have been surprising. And we see these too, where beneficiaries have rights of withdrawal that they haven't exercised at certain ages, certain powers of appointment, and even when trusts are supposed to terminate, but nobody ever got around to terminating the trust. And the trust just stayed intact and everybody kept administering it. So it's kind of, gosh, we've been doing this for the last 15, 20, or 50 years. And now we're looking at it with fresh eyes. What can we do? And they don't want to do necessarily anything particularly draconian at that point, such as completely cut the beneficiary out. But they tend to behave badly and leave a bad paper trail. Kim and I have had the discussion periodically about who makes the better storyteller when these kinds of things are happening. And she is quite sure that she is a better storyteller than the planner who wants to just deal with facts and tax law.
Because litigators are willing to smudge, right? Litigators are willing to dress it up. The estate planners that I know are very, being a witness, even just like in a deposition, is like the last thing they want to do. So, so they try very hard not to get to that place, but also they're really easy to get bad facts from because they just give facts. They don't give the gloss, the smudge. And that's why I say the litigators are slightly better storytellers when it comes to getting to the goal of, no, I don't want it right. I want it favorable. And then it comes particularly important in those things that Shari was just talking about: rights of withdrawal, powers of appointment, a trust that was supposed to terminate, but it never did because nobody really, cared. Everybody was going along fine and it worked out really well. There is like no case law about that, like none. So once the storytellers get in there and they say, well, this is how this should come out, and you're dealing with a judge that doesn't have a great experience with estate planning, and you say, again, they can just get this money anytime. They can just get this money. And it starts to, without a lot of law around it, it is just, how does a judge feel about it? How does a judge feel about this family? How does this judge feel about the beneficiary versus the spouse? It's the old saying of, what did the judge eat for breakfast is going to affect outcomes. And when you have situations where there's just not a lot of law, that is doubly true.
Kim, does it make a difference? Let's talk about the timing. So let's say things don't go well over the holidays this year, and there's an inkling that something could happen to terminate the relationship or not. And people are starting to say, what should I do? how far, this is the question that clients and non-practitioners in this area, is there a bright line test for how far in advance of a filing it would be good to have done a legitimate decanting or change of situs, et cetera?
It depends on the state. And so the analysis for the divorce attorney goes like this. A decanting is a dissipation of marital assets, right? So what happened was the husband actually put into effect actions that took an asset out of the marital estate or took income out of the marital estate. So he dissipated the assets. But for instance, in Colorado, that only works if there really was a talk about divorce somewhere around there. So it could have been 5 years, like a lot of people take 5 and 10 years to get divorced, but they've been talking about it. So if the attorney can establish, no, this was like the first time that divorce was discussed, that's your line. If it's just, gosh, my brother got divorced and that did not turn out well, so let's fix me up, love my wife, but let's fix me up so that I don't have to go down the same path, that's a whole different story.
Does it matter, Kim, if I get a call from the trustee and I'm legitimately representing the trustee, and trustee says, I'm starting to hear some rumblings of discontent. There's no filing. We don't know whether the couple has actually talked about divorce. And the trustee says, I need advice on how to administer the trust and options for planning. If I tell that trustee, all right, the beneficiary is not to be part of any of these discussions, the donor is not to be part of any of this discussion, you and I are working on this, and we're going to look at this from a matter of trust law, the governing instrument, the facts as you present them to me about the current and future beneficiaries. Is that a better fact pattern for you in some of this planning?
Yep, hugely much better. And there's even case law to support that. But yeah, if there can be a Chinese wall around the beneficiary, that helps a lot. And that's where the estate planner can talk about the story of, okay, let's take a couple steps back. This is actually not husband's money. It didn't come from husband's efforts or marital efforts. Keep remembering, Judge, this came from husband's grandfather, from decades ago when he sold the family business. The donor intent was not that husband got the power of the pen to just like give himself checks. You can see donor intent in there. My intent is for my children, my grandchildren, my great-grandchildren to be productive members of society, but I want them to have, a safety net. So when that kind of language is in there, I think the estate planners have a much better story to tell. And then when you create the Chinese wall around the beneficiary, and he's not the co-trustee anymore, and he's not just calling the trustee and asking for money, and the discussions were not had with him about the decanting, then a court can say, well, it's fair. That was within the authority of the trustee to do. It wasn't husband acting badly. It was the trustee and the family doing what they could do, what they intended to do, and what, honestly, I think they had every right to do. And what judges do get, because they are often parents and grandparents, is gifts. Don't count on gifts. You don't get to bring mom and dad's money into things. If they want to give it to you, that's great, but you can't force them to do it by adding it into the estate. So the more you can really cordon things off and tell the story of that, I think the better the outcome is for the beneficiary.
Here's a fact, a couple of facts that I'd like to get your comment on. So let's say you do that and you've prettied up the trust, but nobody's getting divorced just yet. And the couple is in the midst of applying for a mortgage or applying for life insurance, and they don't have sufficient visible means of support themselves. and the lender is looking for a letter from the trustee. And the trustee, of course, if it's a fully discretionary trust, says this is fully discretionary. The beneficiary can't count on any distributions, but is trying to be helpful and says, but historically, we have distributed this over the last 5 years. And the resources of the trust are in excess of Y dollars. Because the trustee is trying to help the beneficiary stand on his or her own 2 feet and do what they need to do outside of the trust. Or for life insurance, to justify the amount of insurance, here it is. And often these lenders or insurers want to know if the trust will back up payment without, not necessarily as a guarantor. So what do you do with that?
A great cross-examination. So it goes like this. Ms. Levitan, I am looking at this letter dated 2 years ago, and in it, you're the trustee, right, Ms. Levitan?
That's correct.
And you said to a lender, an institutional lender, that this trust had distributed regularly to husband, right?
That's right.
And you said to the lender, the institutional lender, that the assets were in excess of $50 million, right?
That's correct.
And you knew that the lender was relying on this representation by you to deem husband worthy of this loan, right?
Yes, but Attorney Willoughby, please understand that in the same.
That's not the question I asked. I think the answer was yes, right?
Yes, but I told that lender that this was a fully discretionary trust and the beneficiary had no ability to promise or compel distributions. So you need to understand that this is fully discretionary, and as trustee, I've decided to discontinue making any payments.
Are you going to tell, you're not going to tell that lender that though, are you?
Well, I have no contractual obligation to do that to the lender. I'm not a guarantor. I'm not a party to the loan. I would be meddling in the beneficiary's business if I did that.
But like that, that's nice. But it is true, Ms. Levitan, that in order to help beneficiary obtain this loan, you represented to lender 2 things, but you knew lender was relying on the second thing, the historical distributions and the assets in the trust.
Oh, I have no idea what the lender was actually relying on because I wasn't a party to that loan.
The loan was made though, wasn't it, Ms. Levitan? So
far as I know.
That's all, thank you. So you did awesome. You are a very good witness. You have had some experience there. But that's how it goes. You know, it's like, there is no good deed that goes unpunished in divorce. So when trustee has helped both of these people, it's only going to be used against the beneficiary spouse. And then the court has to determine which way that's going to roll. Is this something that I'm going to say is property or say is a regular enough gift that I'm going to include it as income for support? It'll depend on how much it seems that somebody is not being a good faith actor. And if husband is not living up to his fiduciary duty during divorce to give full information about this.
So Kim, while you're putting together your financial disclosure for your divorcing beneficiary, you clearly want to see a copy of the trust themselves so that you can adequately describe what the discretions are, what the prohibitions are. Are there any admonitions and any side letters? Do those carry weight?
So I don't think that divorce attorneys know a whole lot about side letters. So they don't get asked for. So there's 2 levels of discovery in most states. The first is the disclosures that just have to be made. Nobody has to ask, it's just, you have to tell the court this information. You have to tell the other side this information. And in Colorado, at least, one of those automatic things that you have to produce is a trust instrument if you are the grantor or the beneficiary or the trustee. And so you produce that. Now, when I do divorces, I am not going to be producing anything extra. I'm going to wait for them to ask if I'm representing the beneficiary's and spouse. And I am not going to be interpreting the trust or summarizing it for them. What I'm going to do is I'm going to throw it out there, and on my disclosures, I'm going to decide for myself whether it's a trust or it's a property interest or not. And that's just kind of a check the box at this level. And I'm going to decide whether I think it's income for support purposes. And if it is, I'm going to put it in the income section. And if it's not, I'm not. And then I'm going to let the other side start challenging my just determinations. And then if they do, then we get into the experts. If they don't, we don't.
And if the trust is a silent trust, which we are now able to draft in many jurisdictions, the beneficiary may have no knowledge.
Mm-hmm.
And the beneficiary may not have knowledge even when the trust is not technically silent. In many families, the donors do not want the trustees to fulfill their statutory obligations, and the money just materializes from somewhere and pays bills from the office.
Mm-hmm.
And nobody really knows that there's a discrete trust here. If I'm not in Colorado and I'm the trustee of this trust, how are you going to get that information from me? Because I have no desire to participate in a divorce that I'm not a party to.
Mm-hmm. So you don't have to be a party. There's uniform acts to allow me to depose you, and there's uniform acts to allow me to propound interrogatories and document requests. And where they're for the states that don't have them, then all we have to do is we start a little action in that state, do letters, rogatory, you get it. It's an extra step, it costs more, but you get it. So you're not a party, but you're still a witness. I can still compel you to do certain things. But I think the bigger question is, but if beneficiary spouse doesn't know, beneficiary spouse doesn't know. And in my experience anyway, when money magically appears, if it's not appearing on a regular basis, spouse just thinks it's a gift. And it is a gift, right? I mean, it's just a gift. They just don't know that there's a trust behind it. And it opens up beneficiary spouse to claims later if non-beneficiary spouse sort of finds out that there's a trust, to reopening the divorce. But if they didn't know, they don't know. So
and they might not be getting a K-1 if the trust is a grantor trust for income tax purposes to the grantor. Or I have plenty of beneficiaries where some family office prepares the tax return. There is a K-1 and they never review the return. They don't know that there's a K-1 from the XYZ family trust.
Yep. No, that's absolutely true. Our clients, a lot of those people have never really looked at their income tax return. They have no idea. Or they'll say, I don't know, it's something, I don't know, it's something of dad's. It's been on my return since I was 10. I have no idea what it is. And
right.
I don't have it. So, and honestly, again, divorce attorneys are not all that well versed with estate planning either, right? So that's where you get so much smudging, because I've had the experience of divorce attorneys just going off on this wild, loud tangent about all this bad acts and the things that I wasn't producing, because they don't know how to read a trust. They don't know how it gets set up. They don't know what statements mean. And so there's a lot to be done by the estate planners to educate the divorce attorneys, to dial back a lot of the nonsense, to dial back the vitriol, just by teaching them how this works, so that not everything seems to be a nefarious act either.
So if I'm hearing you correctly, no matter what that trust says, no matter how reasonable the administration has been, you've got the benefit of hindsight, whether you're representing the beneficiary spouse or the non-beneficiary spouse, and you want to tell a story. And you're looking for as much as will tell the story, including things such as, is the marital home owned by that trust?
Yep.
You know, we have plenty of beneficiaries with just about no assets to their name and no employment.
Yep.
Where
And
everything is in the trust. Tell us about that.
well, those are the hardest for the judges, right? Because they're like, you guys you fed your kids, you educated your kids, you built a life around the fact that you thought you were going to be married together and this trust was going to keep supporting you. And so you don't have any marital assets and people haven't really been working all that hard. For the judges, they want desperately to figure out a way to get the out spouse something, because they just feel like, you know, this person has all this resource and they relied on this, and this person has no resource, and how do I true that up? And that's where a lot of the smudging happens from the judges.
Mm-hmm. So judge wants to find a result. If you're representing the non-beneficiary spouse, you're looking to get some sort of a settlement or a judgment that will provide something. And yet, if I'm serving as the trustee or as counsel to the trustee, I'm looking at a trust that does not have this former beneficiary or former spouse or about to be ex-spouse as a beneficiary. And I have beneficiary spouse who has no ability to compel a distribution or to have me pay his creditors. He does not have a power of appointment that he could exercise to pay off his creditors. How can you, representing the out spouse, compel me as the trustee to do something that would be a breach of my fiduciary duty?
I can't, but I can make things so painful for beneficiary spouse and the family by making it expensive, making it take a really long time, telling the story of how horrible the trustee is and how horrible the beneficiary spouse is, finding the fissures in the family. You know, families don't operate in lockstep. There's always somebody who's willing to say something not awesome about beneficiary spouse. Sometimes the trustee and the beneficiary haven't seen eye to eye. I'm going to try to find those places, and I'm going to try to shake something loose. I know that on paper, trustee can't make this distribution, but I know in reality, there's a way to get some money 9 times out of 10. When you are talking, I mean, 9.9 times out of 10. I mean, even when I'm dealing with asset protection, and I'm not going to talk about offshore, but domestic asset protection trusts, if you make it hard enough, long enough, you can shake the money free, because estate planners are really smart people, and they can draft around a lot of things. And I know that.
So let's say that there is this attempt to garner a settlement here, and you've called me as a witness and to produce documents in an out-of-state divorce, and now you get a judgment, but I'm not sitting in your jurisdiction. And I'm saying, no.
And
what are you gonna do?
I'm going to sit on husband's bank account. So I'm going to say to the court, push, here's what's going on. These people are horrible. Push all the marital assets, such as they are, over to wife. And the trust is going to be forced to make distributions to the husband because he's got nothing else. And I'm going to sit on his bank account, and I'm going to go attach it and get an order about him and make his life as miserable as humanly possible.
Does it matter to you if there are children of that marriage, whether they are minors or no longer minors, in terms of their interests
Mhm.
in this trust? Because as a trustee, representing donors of trusts and trustees, there are often what we call spray or sprinkle and spray trusts, where there are other beneficiaries who are going to get accounts. They're going to see what's going on. They're going to see the outflow for the legal fees.
Mhm.
Where do they fit in?
So for minor kids, so sometimes it's just as easy as, all right, trustee, you're not going to make a distribution to him, but you can make distributions on behalf of the kids. So let's make sure that they have housing. Let's make sure that they have education costs and lacrosse costs covered. So that's where I would be going. I think the bigger question is, well, all right, so if you tap that trust too hard, then what used to be $100 for a husband that could flow down to kids is now $20. Don't you care about that? What about, these joint kids? And that's a conversation that I think is had, but I don't know that many divorce attorneys necessarily get that, unless the estate planners are really, making that information available and kind of telling that story and finding ways to make it so that they can meet their fiduciary duties while at the same time trying to get everybody's goal, supportive kids, met. And I think that's what I have to say about that.
So I have a comment in our remaining couple of minutes. We're sitting here at a time when people are frantically completing, gifting irrevocable trusts that were started when the diminution of the exemption was in play. And the term of art in vogue is to do a SLAT, a spousal access trust, which, as people know, is no more than a garden variety irrevocable trust, of which the spouse is either the sole current beneficiary or one of many. And I have been engaged after the fact in the context of a divorce where one spouse said, these were my assets originally, or spouse gave them to me to create a SLAT so we could do this wonderful planning. And now we're getting divorced, and a whole lot of what would have been our marital resource went to fund the trust for him. And I'm not a beneficiary. His sister is the trustee. Yes, it's for him and his issue. And oh my gosh, he's taken up with somebody and he's about to have a baby with somebody else who's going to be one of his issue.
So that's when you never name the spouse, you just say spouse. But that brings the other problem into focus, which is we have created these irrevocable trusts. We have taken them out of the marital pot, and we didn't think about divorce. And now we can't get at it, or only one person can get at it. And is that a dissipation of asset? And if the trust attorney wasn't really thinking through what happens if there is divorce, are we now going to sue that person? So I think there's a lot that estate planners need to do to keep in mind that people get divorced. And right now, I think is a fraught time for estate planners to be helping people to do these planning things for tax purposes, and not really talking with their clients about what happens if they get divorced, because estate planners don't necessarily want to have those conversations because they're hard.
And particularly if you represent the couple, you cannot be having a side conversation with one that's about to tell you things are really rocky if the other one doesn't know.
Yep.
Because then you can't represent either one of them. So they're disinclined to tell you. Yep. I think we are at about the end of our hour for the presentation. And I see that we have a question. Does the non-grantor beneficiary of an irrevocable trust have the obligation to disclose the size of the trust corpus? think we've answered that question along the way of what is known, what may not be known, and how else you can gain that information. Kim, thank you for joining us today. It is always a pleasure to work with you and to be able to think through these issues from the practical. We estate planners know that if the assets aren't titled properly or aren't liquid when the time comes, the documents may be beautiful but may not do the job. This is another aspect of all of that, both at drafting and administration.
It's been fun. Thank you very much for the opportunity to get to speak with you again.
Thanks so much.